Welcome to Music Row Dealmakers, where we explore our world of making deals from Nashville's famed Music Row, in the heart of Music City. We are the Dealmakers, from composing to closing. Now, here's your hosts, Barry Neal Shrum and Dennis Disney.
Hello there. Welcome to all of our faithful deal makers listening in. We appreciate your continued support and welcome you to this, our 22nd episode of Music Row Dealmakers, from composing to closing. And if I haven't already, I wish you a happy July the 4th coming up. We are recording this on the 1st of July. As always, Dennis and I want to thank each of you for listening in and supporting us as we continue toward growing our list of listeners. Please help us do that by sharing a link to the podcast with your friends on social media. If you haven't already, subscribe. Spread the word. We really appreciate it. I'm Barry Neal Shrum, founding partner of Shrum, Disney & Associates, and with me is my partner, Dennis Disney. And we are the Deal Makers, from composing to closing. Prior to July 4th, Dennis, the Supreme Court has just issued a flurry of its final decisions in their 2025 term. It's kind of oddly named because it starts in October of 25 and runs through the 26th, or 2026. But one of which was to deny cert to Trump in his appeal of the E. Jean Carroll case. And that involved not only a jury's decision that he was liable to her for sexual abuse, but following that, his refusal to accept that verdict, he continued to slander and defame her, and she took him to court for that. So, a number of issues there. But the Supreme Court denied that cert. That was the thing that came out of this most recent flurry, and they sat on that for, I think, 12 weeks trying to figure out what they were going to do with it. As far as our defamation case goes, one we talked about in the last episode, Ryan Upchurch, smoke has finally cleared a little bit for me and Dennis, and we hopefully are, fingers crossed, close to settling that case. So today we decided to turn to a more general discussion, I guess maybe a philosophical discussion, of defamation law in general. Before I get into the history and the background, don't forget, if you'd like to interact with us, you can call us at 877-7-DEALMAKERS or send us an email at questions@musicrowdealmakers.com. We'd appreciate your insights, and we'll take any thoughts we can get. Dennis, slander and defamation have a pretty long history in the politics of America, going all the way back to Thomas Jefferson. Back in the day, I think this was the 1800s, I don't remember exactly, but Scottish journalist James T. Callender was hired by Jefferson's party to write political attacks against his opponent, John Adams. Now, after Jefferson won the election, Callender requested a cabinet position, but he was rebuffed by Jefferson, and so Callender began spreading rumors about him and exposing his alleged affair with Sally Hemings. Back in those days, actual malice wasn't really a component of defamation law. That would come much later, and we'll talk about that case, New York Times versus Sullivan. But I guess in those days you could win a defamation suit for just about anything. So that changed in 1964 when I guess the groundwork for what we're calling the modern law of defamation was established. Now, that was a different world. There were few channels on the television. You and I were the remote at that time. We would be instructed by our fathers or mothers to get up and change the channel to channel 2 from channel 5. I think we had 2, 4, and 5 in this area. There were a handful of newspapers, of course, locals, but you had the New York Times and things of that nature. So there were very few people who happened to own a printing press. So part of the argument, I guess, in our society now is it time for us to adapt the law to those changes? These days, of course, everybody is a quote-unquote news source, newscaster. And that doctrine of actual malice, which we'll talk about, Dennis will talk about a little bit later, hasn't really changed since that time, since 1964, although the world around us has. And part of the argument is that, in those days of the Fourth Estate, those are different. And the doctrine is perhaps stressed. We're seeing larger verdicts, $787 million against Fox, $1.4 billion against Alex Jones, $140 million against Rudy Giuliani. So we are starting to see larger and larger numbers against public figures. And you and I would argue even against Ryan, the $18 million verdict was a little extreme in our opinion. So the question becomes, should the public figure, private figure distinction survive? And when a private person can really go viral involuntarily overnight. Defamation law was built for a world of a few publishers. Today there are billions. So there's a tension. And now we have at least two Supreme Court justices, Kavanaugh and Thomas, who would eliminate that standard of actual malice and have discussed doing so in the appeal by, I think that was, who was that? Anyway, they discussed that in their dissent and denying cert to Dershowitz in his case. So that's the issue we're discussing today. So Dennis, through all of our exposures, and we've got several cases now involving not only defamation, but the Tennessee Privacy Protection Act, which is one of a series of anti-SLAPP laws that we'll talk about a little bit. Give me the elements in plain English. Tell me where the online fights actually happen.
Well, first, good morning. Good day.
Sorry, yes, good morning to you.
You just sort of dove in.
I did.
You did.
Well,
you just jumped right in.
Well, hell, you got me here early, Dennis. I'm geared up to go.
You're not even into your first cup of coffee quite yet. So, and second of all, let me join in wishing everybody a happy Independence Day. It's 250 years this year, but it's also another distinction. It's actually, if I get my numbers right, it is 45 years. The first time I ever met my wife.
Ah, well, congratulations.
July 4th, 1981.
Yeah.
And so we call it the first time ever I saw your face day.
How
Isn't that
nice.
Sweet? Yeah.
Yeah. We need some violins in here.
And then I wanted to come back to Jefferson just for a quick moment. Yeah. Malice might not have been an issue back there, but actual mallets were. They could actually just go beat on each other.
Well,
if they wanted
actually,
to,
I think actual malice was the word of the day. I think that's the day in which they would slap with the gloves and walk out and start shooting at each other. It's like who decided that was a good way to resolve a conflict?
Well, some people will argue who decided it wasn't a good way.
Well,
I heard a podcast just this morning on the way in that jokingly referred to that. Hey,
Well, personally,
when you know what your consequences are.
Yeah, I think personal debate is still got a leg up on a bullet.
I would agree. Like, at least it keeps lawyers in business. So.
Well, it keeps us alive.
Yeah, exactly. This is true. Keeps us alive to pay your bill you owe us, type of thing.
Yeah,
so,
exactly.
Yeah, so I think we touched on it a little bit last time, what some of the elements are under defamation, and under classic defamation, it's a false statement of a fact. It's about a plaintiff. It's published to someone else, which and published doesn't mean that it's printed.
Let's pause for a second.
Yeah.
You didn't mention the word that was left out in the Ryan Upchurch matter, unprivileged. It's an unprivileged false
It is
statement.
unprivileged. That is true. However, even a privileged statement, the privilege is you have the right to say what you want to say until it hurts somebody and causes damages. Then it becomes not a quote unquote privileged statement per se. But even then, I think we can even argue, we have debated even in our office. We talk about, just getting off my notes here a little bit, but let's just jump in. So we talk about what can be said about in the political discourse. And if you're a public figure, the actual malice standard that comes into play there, which means it was reckless or reckless as to whether it was true or not. You just didn't care. And number two, whether it was actually false, right? So
that is true. But the reason I raise it is because of the actual malice standard. I think that the basis of that is the privilege of the press, the First Amendment right to a free press. And I think that was part of the rationale in the 1964 decision that, in my mind, is still important even in today's age.
Well, I think we have to drill down a little bit deeper. It is the freedom of the press and the freedom to speak as it relates to government action, right?
Well, that's not in the First Amendment.
No, but that's what the context, is it not? The government says you have the right to free speech, the freedom of the press, et cetera. And that's true until. There's always an until. So the New York Times can't go just print anything and everything they want. That's why we've had all these flurries, and we're going to get more, I'm understanding, from what I've been reading, from politicians. There was a period, and there were politicians who says, well, they have a right to say what they want to say. Well, that's not actually true. You don't have a right to say anything and everything you actually want to say. You do until it harms somebody appropriately. A public figure, they have a higher bar they have to clear. It has to be a reckless statement that you didn't care whether it was false or not. You just threw it out there. There's more and more case law coming in that even hiding behind the words, well, in my opinion, or I think, or it seems, is not a strong defense anymore. It's not. And I'm not sure that's wrong. It shouldn't be that way. I mean, you need to be, I guess in my words, you have to be accountable and responsible for the words that you say. So when the only true, I guess I should back up on this, the only true protections you have for a privileged statement would be in the well of Congress when you're debating bills, even though there's internal rules about you can't attack personally other fellow congressmen. You're not supposed to do that based on the congressional rules. And so you can get censured and called out. Okay, it's slap on the wrist, but people don't like it. Or in litigation, you're able to bring out things in litigation and you can't sue for that. You mentioned the E. Jean Carroll idea, Trump being a public figure. It's a pretty high bar. He had to show that, hey, she did this with actual malice. But all he really said about her was, after the verdict, if you read what his comment was, he called her a liar. And that's what she sued on. Because, hey, the court said, oh, I did this, or you did this to me, and yada, yada. He said, I don't care what the court said, she's lying. Essentially, that's what he said. So she's sued him for defamation. Okay. And of course, that court ruled in her favor on that, and the Supreme Court has decided not to take it up. So I guess where I'm going without chasing too many rabbits here is a privileged state. You do have a privilege. The absolute privileges still only end up being in the well of Congress, in Senate and House, or in litigation. But after that, you can't just run them up saying things. You said something when we came out of trial, which you and I have debated. You said when the opposing counsel stated in his opening, you can't tell a lie about a grieving family. And you came back to me and said, you absolutely can tell a lie about a grieving family. Only if that lie, quote unquote, doesn't do them real harm. If it does them real harm, they can sue you and they can win.
Well, let's face it, you can be sued for anything. I still maintain my position that was an incorrect statement of the law. And it is based in part on New York Times versus Sullivan. Getting back to that First Amendment principle, the amendment actually says Congress shall not pass any laws. And by Congress, of course, it filters down through the states through the 10th Amendment. So, in other words, any law abridging free speech is prohibited by the First Amendment and abridging freedom of the press. And if the press is not publishing things in order to hurt people, like Callender did with Jefferson, intending to do him harm, then I do believe they can print what they want as long as they have a reasonable basis for it. And even if it hurts somebody, you can't sue somebody simply because you're offended by what they say.
Well,
that's why actual harm is part of the definition
it
as
is
well.
That. There has to be actual damage, actual harm done that can be, even though we know we have defamation per se laws out there that in many states, Tennessee did away with it. They have defamation per se, but Tennessee doesn't do presumed damages anymore.
Right.
California does. In our case,
that was our problem.
That was
with
our
Upchurch,
problem with
yes.
that. But you are correct that you can say whatever you want to say. The government is not supposed to come in and shut you down. The government is not supposed to. But that freedom has a consequence to it. That freedom of speech. That because you just said it, if you can say something that's offensive, but that's not actual harm just because you're offended. Even though California has a line in there that says hurt feelings, can be a compensable damage, which is, I thought, really?
Which is an abridgment.
Wow, that's okay. When do we get so thin-skinned that we can't, say stuff that people find offensive? But offensive isn't, and I think the Supreme Court is ruling this, offensive isn't actual damage. It isn't actual harm per se. It is more of a subjective feeling if you have. But my point to all that comes back to the only absolute privilege you have is in Congress, in the well. If you go out on the street and say it, you can be subject to lawsuit. Absolutely. If you're in litigation, that's fine. And as you saw with Trump and E. Jean Carroll, after the fact, he comes out and calls her a liar. She sues for that. And that was after the first litigation. It wasn't during the litigation. And so the courts and the jury initially said, no, that's wrong. You're going to be paid. You're going to have to pay for that. And so that's why I look at it and I go, okay, so if we're looking at the classic definition for defamation, it is that false statement of fact. So it does have to be a false statement about the plaintiff published to someone else that injures the reputation or causes harm in their business or something like that. And it's made with some level of fault and causing damages. And I think we're saying the same things. I think the distinctions that you and I don't fully agree on is how far can you go with that statement before it crosses over the line. And I think that's going to be fact dependent, personally. I mean, we talked about Upchurch last time. I still, to this day, even though we did not prevail on that lawsuit, but still today, I think the jury absolutely got it wrong. I don't believe anything that he said was injurious to the plaintiffs. Now, the jury thought otherwise. Fine. We respect the jury decision, at least until we file the appeals and all those things that we've been working on.
We've talked about. I think and without getting too far into the appeal, part of that decision, I believe, and we've talked about, was engendered by some of the instructions given to the jury, which lacked the component of privilege,
I think
lacked the component of First Amendment rights. And those, I wouldn't say they were suppressed, but they certainly weren't emphasized. I mean, I emphasized them in my voir dire. But other than that, the jury had absolutely no exposure to the fact that he can make statements as long as they wouldn't injure the normal, reasonable person.
Yes. And I think that's where they lost track personally. It still runs on a reasonable care standard, simple negligence standard when you're a private individual.
Well, and one thing we often don't talk about, and even in our definition that we just cited, is the causal relationship between the fault and the damage. As with any tort law, right? That there has to be a causal relationship. Mm-hmm. There can't be an intervening cause. And that was part of the problem, I believe, in the Upchurch case, is there were intervening causes, obviously. These people had just lost a daughter and a granddaughter. Were those the actual reasons for the harm that they suffered? Maybe accentuated by Ryan, but not caused by Ryan. So, the causation element when we talk about fault as compared to damage is extremely important.
I totally agree with that. And not to belabor the facts in our case, but
Yeah.
everything that happened along the way that led up to Ryan making his statements, he was actually basing his comments on other people's comments.
Yeah.
And that was one of the things we kept trying to draw out was the only reason he was the only one sued was because he had a bigger platform.
Right.
That was it. And they essentially, I think, acknowledged that through our various questioning. They didn't come out overtly and say that, but just the way they answered other questions, you go, okay, so you're really only here because this is the guy that seemingly has the bigger platform, ergo maybe bigger money awards that could be had. But so we get through all that, and I did want to back up just real quick. So there is a primary case, if you want to call it a seminal case, a case from 1990. It's Milkovich that talks about not hiding behind the words, I think, my opinion, it seems, that type of deal. So, which goes back to we all have a reasonable care, which you brought up, to say things that we have at least given some reasonable modicum of attention to as to its truth or falsity, and not just throwing stuff out there. And again, trying to do it without limiting debate. And that was one of the things you and I really tried to stress to that jury, I remember, was rulings like this that they ended up making absolutely can have a chilling effect on speech. Now everybody starts pulling their punches, so to speak. And what happens when you start backing off? Well, then you don't have the same zeal to verbally and publicly talk about some things that really need to be discussed, perhaps, especially if they're of public concern, whether that be political or other just world events that are happening. And I do think that that's a big challenge with a lot of these lawsuits and the big awards that have been granted.
Without getting into too much detail about it, we've got another case that involves a statement, essentially that person A says that person B is connected to the Epstein files. That's similar to Milkovich. That, in that opinion, or in that case, that involved a mayor who took a bribe, and that was the exact statement. In my opinion, this mayor took a bribe. And, you got to look at that and say, was that a correct decision? I mean, is it our First Amendment right to say, in my opinion, this mayor is crooked? Is that a statement of fact, or is that a statement of opinion? And of course, the court said they took it a step further. It wasn't this person is crooked, in my opinion. It was this person took a bribe, which the court said implied a fact, right? So let's take that back to the Epstein statement. Is saying a person is connected to the Epstein files, in my opinion, is that defamatory?
Yeah, obviously we've debated some of that ourselves. And I think that particular wording, to me, doesn't rise to that level. And that's one of the things that we were arguing.
Well, how does that differ from Milkovich?
Well, because of Milkovich, they specifically identified the mayor as taking an actual bribe. What does it mean to be connected to the Epstein files? It could mean anything. It could have meant I was on a guest list with 1,000 people at a fundraiser that he happened to attend. We don't know. So I think there's the breadth of, or the degrees of separation are much broader in our Epstein example than they are in Milkovich with the mayor, because that person took a bribe. It's a very strong, emphatic statement. This person is somehow, in some way that we haven't really identified, connected to the Epstein files. You see, I think there's not a specificity enough to it for that. Now, there was another phrase in our current case you're talking about where it was alleged so-and-so has, quote, pedo friends, close quote. And that, to me, becomes a bit closer because you can read an implication into that. Not that they're pedophiles, but the other person accepts, and finds nothing wrong with pedophilia. You can probably read that into it. And within the context of the full statement, which we're not giving, that person who has pedo friends is identified. I think that gets closer, and we've had that discussion in here.
Yeah, and that one was still prefaced with "in my opinion," and I know what you're arguing here with Milkovich is that it's not a full safeguard, and the reason for that is because you get different juries, different judges, different opinions, and different things about the law. But in my opinion, saying "in my opinion," you have friends who
I'm going to write this down in case
are
I need
hypocrites.
To sue you.
Let me say, Dennis has friends who
As
are
an example,
hypocrites.
yeah,
Okay?
as a hypothetical.
As a hypothetical. That's not defaming you. It's talking about your friends. It's not calling you a hypocrite.
True. But you would have to admit, would you not, that saying someone is hypocritical or saying they have friends that are hypocrites does not have the same social stigma to it as saying you're a pedophile or you have friends that are pedophiles.
Well, no, saying you're a pedophile without regarding the falsity of it is definitely defamatory.
Oh,
there's no doubt about that.
Absolutely, completely agree.
So let's make that clear.
Unless you are, then we have truth as a defense.
Well, then truth is a defense. But maybe we should use a different example than pedophile. But saying, in my opinion, you have friends who are pedophiles is not defamatory because you're not over concerning person B. You're over concerning their friends.
Yes.
And that's not defamatory to them.
And I agree with that. Where it gets a little less definitive for me is because you do have defamation by implication, which is one of the claims in this case we're talking about.
Yes.
So can you imply this and being associated even with that word pedophile? I don't care if you say I think or maybe or it seems. I think it puts our client in a more challenging position than she otherwise would have been had she not used that phrase pedo friends at all.
Well, that may be true, but even in that case, and I don't want to get too far into defamation by implication, that is unique to several states, and Tennessee being one of them, because that involves more context. And you need to view the statement in context in order to see if there is an implication and if a reasonable person would draw that implication.
And that's the issue, one of the issues we had in our Upchurch case, because they pulled
Very
out,
definitely.
And the same thing with this claim you're talking about here, they only included the excerpts, the more salacious part of it.
Right.
And taken out of context, it looks bad when you first read it,
yeah,
or you first hear it.
Yeah.
And I know what we tried to do in the Upchurch case is bring in the full statements. As a matter of fact, we tried to get those included in the jury instructions. It's not just this. You've got to see the whole statement. And we were overruled on that. We were overruled by including all the elements related to, under California law, defamation. The judge said, no, what we have works. We were arguing it's not specific enough. They've been here for 5 days, hearing all this stuff, and all they hear is a sympathetic plaintiff. They're not remembering, we have to actually look at specific elements. Let's keep those in front of them.
Yeah.
And,
well, in that regard, you and I have talked about the fact that a lot of these online influencers are just spouting their opinion, and it's mostly hyperbolic language.
Yes.
And that is, I think we agree, protected by the First Amendment.
Yes.
And so does this shield the, in my opinion, lack of a shield? Does that apply to things like, I'm just asking questions about this? This seems concerning. Are those different? And would Milkovich treat those as, you can pierce those as well?
everything, as we learned in law school, is fact dependent, right? Is this wrong? Is that wrong? Well, it depends.
Yeah.
And I think same thing here, context and what facts we use are so important, including if you're doing it online on a video, body language, facial expressions, all these things come into play. If you just take out the words and put them just on a page, they can look starkly different than what was actually understood from the viewer. It just is. And that's one of the challenges everyone has with email and text. I talk to my wife and kids about this all the time. I said, well, why did you say that? Well, I didn't mean it that way. Well, how am I supposed to know from this text? And fortunately, when it comes to online audio, podcasts, Instagram, YouTube, the dominant case law that we've been able to find is, fortunately, they treat those as slander, which are verbal spoken.
If it's being broadcast live on YouTube.
Yes. And it's not considered libel, meaning written. They treat it like a broadcast, a TV broadcast.
Right.
And the importance for me, or to me, for that is that it gives you all those other elements of context, body language, facial expression, voice tone, all these things come into play. And I think you have to then, as a viewer, assess all that. And you can hear people when they're being sarcastic, and you can hear people when, man, they're really serious about that. And you can view all that. And I think part of our challenge, even though there were clips played and whole clips played in our Upchurch trial, I don't necessarily think the jury remembered that. I think all they paid attention to was, well, here's the statement on the page, but what's the rest of the context that you heard? And they couldn't get over, as we addressed with them very early, spicy language from our client.
And facial expressions.
But all that matters. And I don't think they weighed that in their final decision. And so back to your point, saying I think, or it seems, or my question is, I think are legitimate and protectable in that forum, using that medium, because you can see, or potentially protectable, depends on what they said, but because you can put everything in full context. It's just that when it gets translated down to just type on a page, that people get apoplectic about it.
Well, and to that point, I mean, this is going back to my early days of law when I was in Philadelphia, and we were just starting to use computers a lot more. For those of you listening, yes, I'm that old. And we had one senior partner.
Was it true you and Marconi were best friends?
No,
not that old.
That's just a rumor. I had one senior partner who was not tech savvy, and his emails, because that's where we first started using it a lot. That's when the fax started to disappear. For those of you under 50, ask your parents what a facsimile is. But anyway, we started using email, and Steve Miller was his name. And Steve would write his text in all caps. And me and some of the other attorneys had to get together and go into his office and say, Steve, when you write it in all caps, that means you're shouting.
Yes.
So to your point, it is difficult sometimes to discern the meaning behind written text without context. I mean, from the context of Steve's email, please file this brief by tomorrow at noon. We couldn't tell. Maybe he was shouting. Maybe he really wanted to emphasize that it needed to be filed by noon. So sometimes the context doesn't even help. But getting back to the arguments we're making and what we're talking about, does the 1964 case need to be updated? Does actual malice need to be refined? One of the things I will point out is that our court system, our tripartite government, the judicial system designed to determine whether laws are constitutional, the president designed to enforce the laws or uphold the laws, the Congress designed to make the laws. This has worked pretty good for the last couple of 100 years. And our court systems have, in my opinion, done a pretty damn good job of adapting old common law principles to new technologies. So we have to be careful making the argument that just because there were fewer elements of the Fourth Estate back in 1964, that we should therefore change the standard now. For that, I go back to copyright. You look at when technology started to shift the paradigm, right, from distribution through a handful of record labels to democratization, where everybody had access to that. The laws simply adapted. A copyright was still a copyright. The courts still treated a copyright as a copyright. You had certain protections. But the law, the judges, they're on the forefront of interpreting how those laws apply to these specific facts. I personally think they do a good job.
I agree. I think they generally have. Again, it comes back to there are some specific cases that you go, I don't think I agree with how that ruling came down, but that's been that way from time immemorial, right?
Right.
That's why everybody has an opinion and should be allowed to express that I disagree with that opinion. But it's now become, precedent, so to speak, especially if it's within your jurisdiction or just Supreme Court. Okay, that's fine. And at the same time, it doesn't mean those rulings can't be overturned eventually when newer evidence or different thinking comes into play and a case arises that the court can look at. Things can change. I think our system has allowed, in a miraculous way, for those things to change, whether it be with technology or evolving social norms, within certain parameters. Obviously, murder in the streets is never going to be allowed, thank God.
We think,
yeah. But so I agree with that. And at the same time, always being, as we are as lawyers, sometimes contrarians and skeptics and all that, we also have to keep an eye that juries are human, judges are human, and mistakes can get made and do get made. But our system is set up with a lot of ways to try to address those, which I think is an amazing system. I've shared before, my wife is a big On Patrol Live fan, huge actually. And when I catch it with her sometimes on Fridays and Saturday nights, she marvels at how the people who are pulled over for minor traffic infractions, and they just go off on these cops.
Yeah.
And say, well, this is wrong. You got this incorrect. I didn't run that stop sign. I came to a complete stop on it, and just screams and yells and makes a big fuss. And I keep looking at her. I go, they have a remedy if they think it's wrong. Why are they arguing with the cop over this? Tell them you think it's wrong. Get the ticket, get everything, move on, come back to court.
Mm-hmm.
Your arguing is not going to change the situation. They're not going to simply say, oh, well, now that you've yelled at me for 15 minutes, you're probably right. Go on your way.
Yeah.
No, it actually makes it worse.
My wife has a common phrase when I argue with the cops. She said, look, he's just doing his job.
Yeah.
And that's it.
That's it.
Right? You, to your point, the remedy is, okay, get the ticket, go to court, and argue the facts.
Yes.
And
is it a hassle to do all
there.
that? Sure. But really, you're not going to change anything in that 15 minutes that you're haranguing the guy or the lady officer. And so I think coming back here to even these defamation claims, there are remedies for these things. If you think you've been harmed, then let's go to court.
And that's where the scales of justice come in. So let's assume, okay, we've got fault, we've got all of that. What's the connection to this last element of damages? Talk about that. Now, we know the per se, if you accuse somebody directly of a crime and it's a false statement, and that's per se, or at least as far as damages go, the court can assume damages in many states. That's not what we're talking about here. What we're talking about is not defamation per se, but something that's been adjudged to be defamation. Yeah. Where is that causal relationship? How does that work?
Well, according to law, the plaintiff is supposed to prove with evidence that something how they've been damaged, let me put it that way, and that you specifically caused it. So, case in point, the Johnny Depp Amber Heard trial that happened a couple years back. He ended up winning that case. And one of the things that jurors, when they talked with them later, and the plaintiff attorneys, Depp's attorneys, pointed to was he actually lost a $20 million film because of that. Yeah, that's real damage. Because of what she said, this film production studio or the studio itself said, well, we can't do a film with you because nobody's going to want to come out to watch it. So they dropped him as a lead character. And he had a contract, as most do, that obviously spelled out the terms, how much money he was going to get paid. It probably had a morals clause in it, as most of these do. And they said, yeah, okay, you violated that for this. And, okay, that's real damage. Others could be reputational damage. Now, how do you prove reputational damage? Well, a lot of that is by what people are saying to you. But it needs to be, in my opinion, people who know you and know of you. The distinction being here that in our Upchurch case, they kept bringing up some comments made on Upchurch video posts. People who may have said things against the plaintiffs. Plaintiffs didn't know those people, didn't know where they lived, had no clue how to find them, never brought them up. They just wanted to highlight the comment and show, well, see, their reputation was harmed because of this. Well, not really. I mean, people have to know you for you to have any reputation with that person, I would think. But they couldn't prove, as they should have, that locally people were ostracizing them for whatever reason or stopped doing business with them. And so when you get into damages, you actually have to prove your statement directly caused this. We can show that by this statement and this comment and what it meant over here, and we brought in people to show it. But even then, there has to be some sort of quantitative element to it. What is that? It's not an assumed, it's not like per se. It's not supposed to be assumed. Show me the actual harm or damages from the harm that you allege. And that's a tougher battle to fight for a lot of people. And that's why I have some issues with a lot of these things. Now, I know that we got a little bit in Upchurch. We got into some analysis on the Alex Jones verdict and what that meant. And they brought in experts to say, well, every view is worth this amount of money, and et cetera, et cetera.
You're saying the Alex Jones people plaintiff. Brought in the experts.
Yeah, the Alex Jones plaintiff.
Yeah.
Not Alex Jones defense, but they brought it in and said Alex Jones has such a huge platform that they put a quantitative analysis to that and said each statement, or each viewer rather, was equal to this amount of money. And they had expert testimony to show that, and the jury bought into it, and that's fine. Same thing with Giuliani and some others. And, so the damages part is it's just mathematics and how persuasive you can make the mathematics work. But you have to bring in some semblance of actual proof of those harms. This new case that we're working on, that's one of the things that I've yet to see is these statements might have been made. We don't think they're actually defamatory, fine. But how do you get to the damages you're claiming? No one has claimed that you've been harmed by a reputational ding. You've not lost any business because of it. None of these things have happened. There's been some online harassment, people posting, and that happens on both sides because, as we know, the other party ended up making some commentary.
Well, and I think this is where the modern era sort of affects even ancient tort law, right? When we're talking about causation, and one of the typical cases we go back to is Cardoza's false-craft opinion in the railroad case. Mm-hmm. You may remember that from tort class. Mm-hmm. For the audience, just briefly, a woman was taking her children out to Long Beach. She's standing on the platform of the train, waiting for the train, and a man with a box or a suitcase or something was running toward the train, and the employees were trying to help him get on the train. She was just standing there waiting for the next train. Well, he happened to be carrying fireworks. Who knew, right? And somehow, when he dropped the box, the fireworks went off and somehow caused one of those big weight machines to tip over and fall on Ms. Falscraft. Cardoza says the railroad's not liable because they weren't the cause of the explosion. there was an intervening cause. You talk about difficulty in proving causation. That case, to me, illustrates it perfectly. It is difficult, and in our minds, we can't even logically, at this point, draw a connection to the railroad. Yes, the employees were trying to help a customer get on the train, but could they have foreseen that he would be carrying a box of explosives?
Yeah, that's really, to me, the tenet that comes out of that is the foreseeability, but foreseeability has to be reasonable foreseeability.
It does.
Now, can you reasonably foresee that, if we get back to online defamation, that I make a YouTube post, is it reasonably foreseeable that there'll be negative comments in the chat there that people can post, either against me as a poster or against the subject that I'm talking about? Is that reasonably foreseeable? Probably. But see, now that becomes a question for me of, but
was that the cause?
But was that the cause
of any damage?
And exactly. And so I know there was a lot of, one of the rulings within the case dealt with one of the defendants in our upchurch case, went on YouTube and under one video, one time, posted something, "Why are you continuing to talk about my family?" And that was it. And that particular chain of comments was a couple of thousand long. And we tried to bring out the plaintiff tried to make a big deal out of it, that obviously our client knew and should have taken steps because of that. Instead of just more negative posts happening, and he never stopped making his own comments. What we tried to point out was that was one comment in a whole chain of a couple of thousand, and our client testified he doesn't read that many. You can't. You'd spend all day reading all the comments for one post. You can't go on with your life that way. I saw that as being unreasonable to think that he saw that, and the court disagreed. They allowed it.
Yeah, but to your point, back in the days in 1960s, when the Fourth Estate was a handful of newspapers, right? The way you would comment on a story would be to write a letter to the editor.
Yes.
And that was a big deal. And if they published the letter, obviously, they had noticed that this was causing harm to somebody, possibly.
Yeah.
In today's world, social media, like you said, Ryan has millions of followers. It's impossible, literally, for him to read every comment. So is it reasonably foreseeable he would get notice of the harm he's potentially causing? No, that's not reasonable at all. No.
Well, it's not even axiomatic, if you will, that even if he had seen
that comment,
a comment, and even commented on it himself, that he would ever have seen another one after that. Right. I mean, you're putting an expectation on people that if you're posting, then now you have a responsibility to read every single posting that happens after that, which then gets back to what your original debate here is on privileged statements. Don't those commenters themselves have privilege, if you will, to make their own opinions known? Absolutely.
Well, according to you, if they do harm to the individual, no.
It's always up until.
But this is why, to me, the actual malice, because in New York Times versus Sullivan context, Ryan Upchurch is a public figure.
Yes.
And in order to prove defamation, someone should have to prove actual malice on his part.
Well, it's the other way around, though.
Well, it is. Yes, you're right.
But our argument was that the plaintiffs were limited public figures because they were engaged. The situation that they engaged in. And even, yes, there is case law that says if there are certain circumstances that befall you, not of your making, you didn't voluntarily interject yourself. And I understand that. And I thought this one sort of fit in the middle, because it wasn't just that this tragic event happened to this family. It's that they voluntarily engaged with the community and with national and international media, et cetera. And so that was my argument, that they did push themselves into that. I mean, that said, as a if you're a public figure, we'll go back to the Trump thing. If you said something about him, then they have to show, wait a minute, as a public figure, you have to prove actual malice. Are you sure? There was an instance, I don't know if you remember this, and this is where the privilege does come in, but Senator Reid from Nevada, he passed away a few years ago, but at one time he was the majority leader of the Senate. He's a Democrat, was a Democrat. And in the well of the Senate, he made blatant accusations about another senator who I think was going to be running for president on the Republican side, blatant comments about he's a tax cheat, he does this, all these things. And you go, well, wait a minute, that would even pass the malice standard pretty easily. But the privilege was he said it in the well of the Senate. Couldn't touch it. He didn't say it outside of that. Had he said it outside, then we get back into, okay, well, was that said with reckless disregard for the actual truth, which people, press checked into it, and the accusations were absolutely false, but nothing had happened to him there. So that malice standard, you have some places where I said earlier, it's absolutely privileged, but then you raise that bar really high. Private figures, unfortunately, it's just simple negligence, which gets into the duty. Did you breach the duty? Was what you did the cause of the harm? What are the damages? And I know we kept really stressing hard, you got to hit every one of these every one of these elements. And we kept trying to point that out to the jury, that the only thing that they could really point to was our guy made a statement. Okay, that was really it. But all these other ones, we didn't think they met. And that's why we thought the judgment was so egregious there. And I'll be honest, I'm a little surprised the Supreme Court didn't take up the E. Jean Carroll matter for a lot of the reasons we're talking about here. And I don't know why I haven't read the opinion fully. I know there were a couple of dissents to that, but it was a 5-4, I think. It might have been 6-3, but I think it was 5-4. And only because I think what we're talking about, it does start mattering. Like, well, wait a minute, what? Even public figures have freedom of speech, right? They should have, even if you don't like them, even if they're offensive. And I don't know all the facts of the case, so I just know what headlines I've read, really. But if it's true, as my sense of it is, all he said was the jury got it wrong and she's a liar. Is that defamation per se? Well, first of all, it's defamatory. Okay. But in the broad scope of things, really, everything that gets said out there, really, that's it. Is it per se defamation? I don't know the facts of the case. My point is that there's not a bright line that you can say this isn't, except for, there are very specified elements under per se defamation. Communicable diseases, that you are for lack of a better word, a crooked businessman or woman, that type of thing. And 2 or 3 others that are actually enumerated in most of the statutes that we've seen for per se. Okay, fine. We can do that. Then we still get back to the damages. Okay, that might be per se, but are the damages presumed like in California or not like in Tennessee? And if they're not, you got to show the actual damages. In California, you don't have to show them. They're presumed, and the jury's free to pick a certain number, whatever they feel. So I thought it might be good, at this stage to would have been better if the Supreme Court had at least taken a look at it, heard all the arguments fully, and it came out on whichever side they came out on. Fine. I thought it might have brought a little bit more clarity to some of this, because that's one of the challenges with defamation. One of the things I find so intriguing, it is so fact dependent and context dependent, and there's not a bright line except on some elements of per se. There's not a real bright line there. And that makes it fun. I mean, from a weird lawyer sense of in trying to figure these puzzles out. Mm-hmm. But I think this is going to be an ongoing thing that's happening. We're going to see more and more of these lawsuits pop up all across the board. In the age of social media, where you mentioned the word democratization, the democratization to, quote, publish now, it's never been this way. So anybody with a smartphone can become a podcaster, an Instagrammer, a YouTuber, and pontificate and express opinions on anything in the world, and which is amazing when you think about it. But I think it's also going to create a lot of challenges for what really is something that is unlawful. And even if it is unlawful, to what degree is it unlawful? What are those damages? And these headline damages like Alex Jones and Giuliani and even the first E. Jean Carroll matter against Trump, all those things, it just feeds into this idea of, hey, you said, well, we just experienced that. You said this bad about me, and boom, you know. Now, granted, ours, there were two plaintiffs, and so it was like a 67%, closer to 55% of the money went to one plaintiff, for the other went to the other plaintiff. So it's almost like a double whammy, you know, idea. You look at, if there's only one of those guys, that would have been cut in half. That be my sense of it. But I just find this whole area of law, which we're still trying to find all the nuances and things to, just immensely fascinating. For all the things we talked about, you know. I mean,
it is.
And we do so much in the arts. You know, we're entertainment lawyers.
Right.
That's
we deal with
primary.
A lot of public figures.
But my point is the freedom to share your opinions and your thoughts is supreme for us. I firmly believe in that freedom of speech.
Without a doubt.
Absolutely.
Without
and if
a
you're a writer, a singer, speaker, author, actor, you should believe in the freedom to say what you feel and to share that. Where you have to watch is you're free to do that up until it causes someone real harm. I say real harm, actual harm. Then they might be able to sue you for it. So you got to be a little careful, but at the same time, we should want to protect our freedom of speech in this country.
I think
as deeply as we can.
That's paramount, and that's one of the reasons I would say I think the actual Malice standard of the New York Times should stay sacrosanct, despite what a lot of people are saying. I do realize that, and you use the Alex Jones case, and that is perhaps one of the highest damages awarded for defamation. But that case, to me, was very clear and very distinguishable from what Ryan did in this case involving the Rodney girl. He was, as we've argued, stating his opinion hyperbolically. That, to me, was his First Amendment right. Alex Jones, on the other hand, and back to Ryan was one, as we argued, of a chorus of people across the world talking about that case. Yep. That's what got him interested in it. Yep. Alex Jones, on the other hand, was claiming that shooting at a school was fake. That is irresponsible.
And he was essentially the only one.
He was the only, as far as I know, the only one claiming that. And so I don't sympathize with him in that decision. And I don't see that as a bad decision. We are getting close to an hour here. So I'm thinking, just for the audience, Dennis and I had planned, and you can tell this is a passionate topic for us. We had planned to do this all in one sitting, but we've got another section that we're going to be talking about, which is the anti-SLAPP component of this issue, which is important. And my guess is we're probably going to spend about an hour on that. So what we're going to do is cut this short right here.
Short, it's been an hour.
Well, how about cut it off right here? We're going to end this nonsense right here.
We actually have work to go do.
We do. And do that section maybe next time. So we hope you'll join us. We'll talk about the Cardi B case a little bit. We'll talk about those anti-SLAPP provisions. The federal ones are in Section 230, I think. What statute is that, Dennis?
Yeah, Section 230 of the Telecommunications Act.
Oh, that's it. Yeah, and then we'll talk a little bit more about some other First Amendment limits and cases and Supreme Court cases like the Nazi case that we mentioned in the last episode. And so we've got a lot more to talk about. We hope you'll join us in a couple of weeks when we revisit all of that. We appreciate, again, your support. We hope that you enjoyed this episode, and we will see you again in a couple of weeks.
Music Row Dealmakers is a production of Shrum, Disney & Associates, recorded on location on Music Row, the heart of Music City, Nashville. Subscribe to future episodes wherever you enjoy your podcasts.